That's serious. He took Mr. McLean serious because his training and experience tells him, take him serious. Mr. McLean had every opportunity to see what he was up against. He was pushed backwards. Officer counsel said he thought it was done then. But in a moment, McLean comes forth and he strikes him in the jaw. At that moment, Mr. Counsel has decisions to make. Immediate decisions. He needs to determine what he needs to do. Bring control back to this situation. He eventually picks him up and he throws him to the ground. He lands awkwardly between his legs. He lifts him again, and when you look at the video, the second lift, you see that his hands are parallel to the ground, just like this. Does he have the time to see how he landed the first time? Does he have the moment to, let's check and see what's going on? He's got one thing in mind. His training says that the threat is not over until he's handcuffed. So he picks him up again, repositions him, puts him back to the ground, and still will not release him. Still holds on. Because his training and experience has taught him that even though they may be on the ground, on the floor, he can still do something. He doesn't know the extent of his injuries. He calls for backup, and after calling for backup, he continues and he finishes putting the handcuffs on. Intentionally drop him on his head? Does he intentionally? Do you ever see him turn him upside down intentionally just to drop him on his head? He's been trained to use takedown moves. So he's taking him down. Is it deadly force? No. Is it force that may have ended in Mr. McLean losing his life? Yes. But is every force that causes death a deadly force? Is it the end result that determines what happened back here? If two kids, teenagers, are wrestling in the yard, one simply flips the other, horse playing, hits his head on a rock or breaks his neck and loses his life, was that deadly force? No, it wasn't deadly force. It wasn't deadly force at all. It was no more than an accident. Ladies and gentlemen, you've heard the testimony of Mr. Maxfield, the legal counsel too. Went through his policy. Talked about when hands-on force should be used, could be used. You heard Mr. Counsel tell you that this was something that continued, and it continued for approximately 10 seconds. We're not talking about a situation where he's thrown to the floor and then he steps back and then all of a sudden I'm going to come back again and give him some more. No. Continuum. It's a continuum. Look at the video. If you recall the video, think about this. Mr. Council pushed Mr. McLean away. About what Mr. Council pushed him away. He didn't advance against him when he saw him in a disadvantaged position. He didn't do that. He didn't advance him to try to catch him standing up to land a blow or anything of that nature. No, he didn't do that. He pushes him away and he stands. One hand with mail in it, he thinks it's over. Okay, Mr. McLean, you've invaded the space, step back. He doesn't charge him or anything of that nature. He merely stands there. As an officer of the law, what happens? McLean charges forth, punches him. And as a result of that, Mr. Council takes him down to the floor. He exercises the authority that he's given. Officer. Who is he? Grew up in a small town, North Carolina. 7 years of age. Finished high school. After finishing high school, he went to college. Obtained his degree. Husband. Wife, he told you, Raleigh PD. Family of law enforcement officers. Alone on a car. He's a man that merely did what was necessary to gain control of a situation. Not the aggressor. You may say, well, he pushed him first. That motion came. Even then, that split second, he has a decision to make. And you read the policy, or you heard Mr. Maxfield talk about the policy. The officer doesn't have to wait until he's assaulted. He doesn't have to stand there and say, okay, let me take a blow. Down to the floor. Mr. Maxfield told you that the officers, even though he doesn't conduct the training, these officers are taught takedown moves and different types of throws. You can see from the film that he in no way intended to drop him on his head. We believe that the judge will instruct you according to the law. And we believe that you will have to decide whether my client is guilty of voluntary manslaughter. Voluntary manslaughter is the unlawful killing of a human being by an intentional act. The court will instruct you, now I charge that for you to find the defendant guilty of voluntary manslaughter, the state must prove these things beyond a reasonable doubt. First, that the defendant killed the victim by an intentional and unlawful act. It was an assault that was likely to cause death or serious bodily injury. There is no unlawful assault we would contend to have occurred. He's a detention officer that's been assaulted, and he responds accordingly. Secondly, you would have to find that the defendant's act was a proximate cause of the victim's death. The proximate cause is a real cause. A cause without the victim's death would not have occurred. If you find any reasonable doubt about either one of those, you have to return a verdict of not guilty. And we would contend that the law supports a verdict of not guilty. The only verdict that is supported by the evidence and the law. There was no unlawful act committed by Mr. Counsel. He simply did his job. What would we expect him to do? What would we expect him to do? When we employ him and place him there, amidst 56 individuals, what would we expect him to do? Is that the time to be passive? It's the time to take control, bring order. Exactly what he intended to do. You should find him not guilty of voluntary manslaughter. Then you would have to consider whether or not he committed the crime of involuntary manslaughter. For you to find the defendant guilty of involuntary manslaughter, the state must prove two things beyond a reasonable doubt. First, that the defendant acted unlawfully or in a criminally negligent way. Defendant's act was unlawful if defendant committed a simple assault on the victim. Criminal negligence is more than mere carelessness. The defendant's act was criminally negligent if judging by reasonable foresight, not hindsight. Foresight. It was done with such gross recklessness or carelessness as to amount to a heedless indifference to the safety and rights of others. That just does not exist. And second, the state must prove that this unlawful or criminally negligent act proximately caused the victim's death. Then the judge will read this to you. If the victim died by accident or misadventure, that is without wrongful purpose or criminal negligence on the part of the defendant would be not guilty. Not be guilty. The burden of proving accident is not on the defendant. The defendant's assertion of accident is merely a denial that the defendant has committed a crime. The burden remains on the state to prove the defendant beyond a reasonable doubt. Look at the totality of the circumstances. Very unfortunate. Very unfortunate. But Mr. Counsel at no time committed an unlawful act. He merely conducted himself according to his training, according to the policies and procedures that govern detention officers, county detention. That's what he did. That's what he did. It took him approximately 10 seconds to execute that. Approximately 10. That's how fast. Therefore, ladies and gentlemen of the jury, based on the evidence that we've heard, based on all the testimony, we ask that you return a verdict of not guilty. A verdict of not guilty on voluntary manslaughter. A verdict of not guilty on involuntary manslaughter. And I will leave you with these words. We call to the stand Mr. Theodore Brown, Captain Theodore Brown, his immediate supervisor. And he described him as a man who loved his work, a man who was dedicated to his job. All around. Good man who simply we ask that you return a verdict of not guilty on all charges.
Mr. Willoughby, the jury is with the state.
Thank you, ladies and gentlemen of the jury. Appreciate you agreeing to be on jury duty. It's been, yeah, this is it's a busy time of the year. You've all pushed aside things in your life that were important to come and sit and render justice. And sit as the voice of this community, the conscience of this community, to decide what is and what isn't a violation of the law. You sit as Lady Justice sits. We've all seen that figure since we were children in school. And we remember Lady Justice sits there with the robe. In one hand, she holds scales. She has a blindfold on. You notice what's in the other hand? In the other hand, she has a sword. And it's not only her duty to decide what the facts are, but to enforce the law. And that's your duty here today. You are the people in this community that enforce the law. It's not the State Bureau of Investigation. It's not the judge. It's not me. It's you. 12 people that hear this case. What is and isn't a violation of the law. And this is a sad case. It's sad because Sean McClain did not deserve to die. He did not deserve to be killed. And even sadder is he didn't need to die. There wasn't a need for this to happen. But also sad in this is the fact that Markeith Council does not think he's done anything wrong. doesn't think he's violated the law. He thinks he's within his rights to do what he did. And you listen to him testify, and perhaps maybe even indication of sadness is that, not one time in his testimony did you hear any remorse or any concern for the fact that he had killed someone. Not one time did he say, I'm sorry. Didn't one time say, things got out of hand. I overreacted. He didn't at any time make any indication that he had done a thing wrong. And that's the way he feels. He feels as though he has not done anything wrong. And you could see that in his attitude about inmates. He talked about the inmates in response to some of Mr. James' questions. And Mr. James is a good lawyer. He is a very good lawyer. And he's done a very good job in this case. He's very skilled. But even as skilled as Mr. James is, he can't make some of the facts go away. And that's what we want to talk about in this case, is some of the facts. But when Mr. Counsel got up and testified about the inmates, he kept talking about, they just want more. They just want you to give them more sheets, or they want to give you to give them more laundry, or the inmates want this. And then when his discussions about having crosswords with Sean McLean about his fingers being in the trap, and I told him, if you don't want your fingers get hurt in the trap, get your fingers out of the trap. His whole attitude about what his role is and what he's supposed to do and how this is supposed to operate in our society is completely skewed. In every case we try in this courthouse, we have to ask ourselves why. Why are we trying this case? What's here? And in many of the cases, and I think in this case in particular, the reason that we're trying this case is Markeith Council won't accept any responsibility for anything he's done. It is not his fault. He is not responsible, and he is not accountable. But what I submit to you is that this happened for a number of reasons. And one of them because Markeith Council has got some anger bottled up inside of him. In the way he talks about the inmates and the way he carries himself, he's got anger bottled up there. And he called Sean McLean up. When he's standing there, they've had crosswords, they're standing 10 or 12 feet away. He calls him out in the middle of the room by himself, and he wants you to believe that he did that to try to diffuse the situation and make it go away. When what he did was call him out in front of everybody in there, because he's going to publicly discipline him. He's going to embarrass him. He's going to show him who the boss is in F1. There won't be no misunderstanding about who's in control and who's in charge and who makes the rules. And so Sean McLean is over there minding his own business, having a conversation with another inmate. Markeith Council calls him out to come over here and get in the middle. And that's when folks start to scatter because they see what's going on. They know some drama's getting ready to happen. Something's going to go on. And then if you'll notice, and I'm going to play this video for you one more time in a few minutes, but I want you to think about it when it gets in there. The very first time anybody's in anybody's face is when the defendant, Markeith Council, starts waving his hands in Sean McLean's face. Sean McLean's standing there with his arms by his side. And Markeith Council starts waving his hands doing that. And that's okay for him to do that. But later on when Sean McLean does it, it's not okay. That's a violation of the space. And that's his mindset. His mindset is things are okay for him to do them, but they're not okay for somebody else. And then when Sean starts waving his finger, he knocks him out of the way. Now, Mr. James would like you to believe that he just pushed him out of the way, but that's not the way it appeared to me on the video. And I want you to look at the video when it comes and see. It looks like he gave a sharp knock that knocked him charge of murder. That's what we'd be trying, but we're trying a case of manslaughter. Not because he intended to kill him, but because he intended to do the act which led to his death. That he intended to hit him, that he intended to pick him up and throw him down, that those were intentional acts. They're not accidental. And the fact that someone died, we may use the colloquial expression that he died accidentally, but the being thrown down was not an accident. That was an intentional act. The result of it may be more than anyone anticipated, but it was an intentional act. Now I would submit to you that he did that, and that when he did it, he didn't intend to kill him, but I think he did intend to hurt him. I don't think it's reasonable to think you can pick somebody up and throw them down and expect it not to hurt them. And when you watch this on the video, I want you to look at the way that he threw him down. He didn't pick him up and hold his hands, as Mr. James would suggest, and drop him. What he did was he'd pick him up and he would throw him, and he would go down and use the entire weight of his 290 pounds and his strength to throw him down. Not pick him up and drop him, but watch what he does. Watch his legs go down when he throws him down on the video, and when you see it in just a minute. And see if you don't agree that that's what he did. It wasn't a question of dropping somebody. This was designed to show who was boss in this pod, and he wasn't concerned about anybody else. He wasn't concerned about being overpowered. There was a microphone on his shoulder that all you have to do is mash that button and say all available. And you'll see that when you look at this video. You'll see after he throws Sean McLean down for the second time, before he puts the handcuffs on, he reaches over and calls all available. And then he rolls his limp, lifeless body over and puts the handcuffs on him, and within about 15 seconds, the place is flooded with other officers. You know, that same 15 seconds, if when the altercation had started, he had just reached over and said, all available, none of this would have happened. You wouldn't be here this week, here in this case. Sean McLean wouldn't have been killed. None of this would have happened. But it happened because Markeith Council decided that he was going to enforce order and he was going to show him who was boss. If you look at the elements of the instruction, I believe this case is a voluntary manslaughter case. I agree with Mr. James. It's not involuntary manslaughter. This is not some unintentional act. It's not some simple assault like a pushing or shoving that caused somebody's death. This is an act that was likely to produce serious bodily injury or death. And I think what the judge will tell you is that to show voluntary manslaughter, the state must prove to you two things beyond a reasonable doubt. At first, that the defendant killed the victim by an intentional and an unlawful act. Not an intentional killing, but an intentional and an unlawful act. It was an assault that was likely to cause death or serious bodily injury. Even Mr. Maxfield, who wanted to be as supportive of Mr. Counsel as he could, acknowledged that throwing someone down like it did would create serious bodily injury or death. It happened in this case. It created a death. It is by definition, that's what it is. Don't think there's any question about that. And second, the defendant's acts was the proximate cause of the victim's death. A proximate cause is a real cause, a cause without which the victim's death would not have occurred. And both of the physicians that came in and testified, Dr. Garner and Dr. Scott, both would tell you that those injuries were what caused his death. So there's no element, no issue about either one of those elements in this case. And we have to prove these beyond a reasonable doubt. And ordinarily you as jurors have to rely on witnesses to paint you a picture, to come up and tell you what happened after the fact, to tell you of their perception of what happened. And you have to filter through their perception and their bias on their ability or inability to recall things. You are in the unique position that very few jurors ever are. You got to see the crime yourself. You don't have to rely on someone else. You saw it yourself. Now, you've watched this video and you know exactly what happened. You don't have to rely on either Mr. Council or any of the inmates or anyone else. Because there is no reasonable doubt in this. There is no doubt as to what happened. You see it. You saw it with your own eyes. And it's interesting, we spent a little time talking about the use of force. And as I said, Mr. Maxfield even acknowledged that under the definition of deadly force, that any use of force that would reasonably tend to result in death or serious bodily injury is deadly force. And over under the policy in number 3, a detention officer may lawfully utilize deadly force to prevent or stop a life-threatening assault on themselves or another person. There was never at any time in this case a life-threatening assault on Markeith Council. It didn't happen. You saw it. The most that happened to him was he got struck on the cheek or the chin that caused some sort of bruising or swelling, for which he took some pain medicine. That's not a life-threatening assault. There's nothing about this that was a life-threatening assault that would lawfully authorize him to use deadly force. And a detention officer is authorized to use whatever degree of force reasonably appears to be necessary to defend the officer or a third party from imminent assault. What force is reasonably likely or reasonably necessary to use? And even if you get to the point that you say you can pick him up and throw him down, you get one freebie. You get to do that one time just for giggles. You know, just for whatever you want to do, you pick him up and throw him down. But how can you possibly look at the second time in which he was picked up and thrown with force to the ground and say that it reasonably appeared necessary to do that to defend himself? I want you to think about this. This is a continuum of things, but there are several different acts. There's shoving him away, and we give him that. There's wrestling with him and not taking him down. We give him that. And he picks him up and he throws him down, and we give him that. And then the last time, you turn and immediately pick him up and throw him down again. That's the part that's inexcusable in this case. That's the part for which there is no reasonable necessity to use that kind of force. If you wish to go back and review these, you can ask the judge and he can allow you to go back and look at some of these exhibits that are here. But I want you to look at this video one time and I want you to think about what's in there. And I'm going to give you what my impressions are, and then I want you to look at it and you decide for yourself what it shows or doesn't show. But I think it will show that Sean McClain is standing underneath the stairs, the bottom of the stairs, and Markeith Council calls him over. And he does, and he even tells us, yes, he summoned him over to talk to him. And when he gets over, I think it will show that they stand there and they have some discussion. And people can tell, you can tell from the movement that it must be loud, it must be some heated, because folks start backing away and they start moving up and they give them space. And then there's a little circle out here where it's the two of them. Then you see Markeith Council start waving his hands and his arms. Then the discussion continues on and they stand there and they move around, and then you see Sean McClain raise his finger up, and I think on two different occasions. I think he does this and I think he moves around and shakes his finger and doing that. And something about that upsets Markeith Council, and he shoves him across the hallway, the passageway there. And he stumbles back and catches himself on his hand to keep from falling. And he gets up and he comes and runs right back at him, and he tries to hit him, and apparently does hit him somewhere on the chin, enough to cause bruising. And at that place, I think you'll see Markeith Council bend over and wrestle Sean McClain and get him down, not completely to the ground, but get him down to where he's got a hold on him, where he could take him and put his handcuffs on him, do that. But instead of doing that, instead of going down and putting his 290 pounds on him and putting his knee on him and handcuffing him and this be the end of it, he picks him up and throws him down. And when he falls down right between his feet. And then he immediately picks him back up again and turns and kneels and throws him down a second time. And then once he's thrown him down the second time, he reaches over with his hand, I believe it's his left hand, to his right shoulder and touches his microphone, calls for all available, reaches back, gets his handcuffs, turns the body over, and then handcuffs him. And in just a few seconds, you see other officers coming in. But in all of that, I want you to think about what this defendant is charged with, whether or not it was an intentional act, whether it was an act that was likely to result in serious bodily injury or death. Your Honor, if I may publish this exhibit to the jury. Back. I'm going to turn this on and I ask you to watch for those things as you go through that, I want you to think about each one of those steps and what happened and whether or not that was force that was reasonably necessary to be used under the circumstances. I want you to think a little bit about some of the witnesses that came in and testified. And Miss Gilbert got up first. It was her brother. It's a sad occasion for her. And it was kind of interesting that Mr. James asked her about all the things her brother had been convicted of. Now, I don't know what relevance that had to what he was in jail for now, other to embarrass her and make her feel bad. But, think about that. I mean, why was it necessary to do that? Did that have any bearing on what he did in this particular situation? Or was that somehow designed to make you feel like that he's somewhat less than human, or he's less than deserving of the same kind of fair treatment that everyone should get? And we had Agent Smithy and Agent Thompson that had the video and the tapes, and then we had 4 inmates, and those 4 inmates came forward and testified. And I asked you about that during jury selection, and you all said you could listen to them. And in this case, you don't have to extend a great deal of faith because you can see what happened. They give you the vantage point of being there and telling you things that you might not be able to hear,
But they did that. They had the courage to come forth, and that wasn't easy. I mean, they've got to go back and live in that world of custody. They've seen what's happened to one inmate. They have no idea whether this defendant is going to be accountable for what he did, but they had the courage to come forward. And you may not think very much of them. You may think that they're not deserving of much because of whatever crimes they did or didn't commit. But I submit to you that it took some courage to come here in this thing, in their orange and white uniforms, and get up on the stand and testify in a case against a guard, knowing that they've got to go back into that same prison environment. Then you heard from Nurse Fine, and you heard from the EMS people who both used heroic efforts, and I think they should all be commended at being able to keep Sean McClain alive, to get him to the hospital to try to get treatment. The quick action by Nurse Fine of getting CPR administered to him, and EMS folks did that. And then we had Dr. Garner and Dr. Scott, and both of them told you about the nature of these injuries and what happened and what they were caused and how they were caused, and there really didn't appear to be empty controversy about that, particularly with Dr. Garner explaining the injuries being like a shallow diving incident where someone hits on the top of their head and the compression causes their bones in their spine to break. And so with that, there was no question that the injuries in this fact caused Sean McClain's death. I don't think there was any reasonable question about that after hearing from both of them. In just a few minutes, the judge is going to give you a charge, and he's going to tell you that you should apply the law as he gives it to you, not as you think it should be, because it's important that the law as it's applied in this case is the same law that's applied to everyone. And that's what I encourage you to do, is I encourage you to apply this law even-handedly. And in doing that, I want you to think about what the concept of justice really means, of justice and fairness. And in order for you to look at this thing and make sure that you're being fair, what I want you to do is to go back in, and for just a minute, I want you to close your eyes, and I want you to think about this video you've seen. And I want you to reverse the roles. I want you to put the guard uniform on 119-pound Sean McClain. And I want you to put the orange and white striped uniform on Markeith Council. And I want you to think about if you were here trying this case, and Sean McClain was the guard, and you saw him being picked up and slammed down on his head, and you saw him being picked up and slammed down on his head again, what standards would you use? Isn't Sean McClain worthy of the same law? Isn't he entitled to the same protection of this jury? Markeith Council is. I ask you, when you do this, that you close your eyes and that you're sure that what you've done was justice, and that you hold Markeith Council accountable for what he's done. And I ask you to convict him of voluntary manslaughter. Thank you.
Members of the jury, all the evidence has been presented. It's now your duty to decide from this evidence what the facts are. You must then apply the law that I'm about to give to you to those facts. It's absolutely necessary that you understand and apply the law as I give it to you, and not as you think it is or as you might like for it to be. This is important because justice requires that everyone tried for the same crime be treated in the same way and have the same law applied. During this trial, I have, in my discretion, allowed you to take notes. We have kept those notebooks on our breaks, but now when you go to the jury room to begin your deliberations, you will be allowed to take those notebooks with you. If you took notes, you may refer to your notes during your deliberations to refresh your memory as to what the evidence was. As I've already told you, your notes are not entitled to any greater weight or evidence, or any greater weight than the individual recollection of the other members of the jury, and your notes are not an official transcript of the trial. Along those lines, regarding the taking of notes, I'm going to read to you the jury instructions that we have prepared in this case. I'm also going to give you a copy of what I'm reading. So if you feel compelled to take notes now to the instructions that I'm going to read to you, you feel free to do so. But I may save some of you some time or effort by letting you know that you will receive a copy of these notes, and I'll give you more instructions about the things that you're going to receive in just a few minutes. The defendant in this case has entered a plea of not guilty. The fact that the defendant has been indicted is no evidence of guilt. Under our system of justice, when a defendant pleads not guilty, the defendant is not required to prove the defendant's innocence. The defendant is presumed to be innocent. The state must prove to you that the defendant is guilty beyond a reasonable doubt. A reasonable doubt is a doubt based on reason and common sense, arising out of some or all of the evidence arising out of some or all of the evidence that has been presented, or the lack or insufficiency of the evidence, as the case may be. Proof beyond a reasonable doubt is proof that fully satisfies or entirely convinces you of the defendant's guilt. You are the sole judges of the believability of each witness. You must decide for yourselves whether to believe the testimony of any witness. You may believe all, any part, or none of a witness's testimony. In deciding whether to believe a witness, you should use the same tests of truthfulness that you use in your everyday lives. Among other things, these tests may include the opportunity of the witness to see, hear, know, or remember the facts or occurrences about which the witness has testified, the manner and appearance of the witness, any interest, bias, prejudice, or partiality the witness may have, the apparent understanding and fairness of the witness, whether the testimony is reasonable, and whether the testimony is consistent with other believable evidence in the case. You are the sole judges of the weight to be given to any evidence. If you decide that certain evidence is believable, you must then determine the importance of that evidence in light of all the other believable evidence in the case. There are two types of evidence from which you may find the truth as to the facts of a case: direct and circumstantial evidence. Direct evidence is the testimony of one who asserts actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of a chain or a group of facts and circumstances indicating the guilt or innocence of a defendant. The law makes no distinction between the weight to be given to either direct or circumstantial evidence, nor is a greater degree of certainty required of circumstantial evidence than of direct evidence. You should weigh all of the evidence in the case. After weighing all the evidence, if you're not convinced of the guilt of the defendant beyond a reasonable doubt, you must find the defendant not guilty. Photographs were introduced into evidence in the case for the purpose of illustrating and explaining the testimony of a witness. These photographs may not be considered by you for any other purpose. A video was introduced into evidence in this case. This video may be considered by you as evidence of facts it illustrates or shows. Evidence has been received tending to show that at an earlier time a witness made a statement which may conflict or be consistent with the testimony of the witness at this trial. You must not consider such an earlier statement as evidence of the truth of what was said at that earlier time, because it was not made under oath at this trial. If you believe the earlier statement was made and that it conflicts or is consistent with the testimony of the witness at this trial, you may then consider this and all other facts and circumstances bearing upon the witness's truthfulness in deciding whether you will believe or disbelieve the witness's testimony. Evidence has been received concerning criminal convictions of the witnesses or of witnesses. You may consider this evidence for one purpose only. If, considering the nature of the crimes, you believe that this bears on the witness's truthfulness, then you may consider it, together with all other facts and circumstances bearing upon the witness's truthfulness, in deciding whether you will believe or disbelieve the witness's testimony at this trial. You may not consider this evidence for any other purpose. Now, members of the jury, before I get into the substantive instructions, I want to take a minute to go over this envelope. You're going to receive this envelope shortly after you get to the jury room. When you receive this envelope, that's the signal or the sign that you are permitted to go ahead and begin your deliberations. Inside the envelope is a notepad. There is also a copy of the jury instructions that I'm reading to you now, and there's an ink pen. Any correspondence or question or issue that you may have, we ask that you put it in writing, knock on the door, and give it to the bailiff. That's why the notepad's in here. There will also be a verdict sheet in there, in the envelope. The verdict sheet is a one-page document. The top of the form has what we call the caption of the case. It has the jurisdiction is set out, the state of North Carolina, Wake County. It has the parties, the state of North Carolina versus Markeith Council, and it says it's a verdict form. In the body of the document, it says, "We, the jury, by unanimous verdict, find the defendant, Markeith Council, to be," and there are three options. It is your duty to deliberate upon the evidence, consider all the evidence, and reach a unanimous decision as to one of these three verdicts. From the evidence, you'll find out what the facts are. You will then take those facts and apply it to the law that I'm giving to you and determine one of these three verdicts. And the three verdicts are guilty of voluntary manslaughter, or guilty of involuntary manslaughter, or not guilty. Your foreperson should check or X or mark some way whatever of those three options you select. And then there's a place to date and sign and print the foreperson's name. But this form, as I said, will be inside the envelope that you're going to receive shortly after you get to the jury room. The defendant has been accused of voluntary manslaughter. Under the laws and evidence of this case, it's your duty to return one of the following verdicts. 1, guilty of voluntary manslaughter, or 2, guilty of involuntary manslaughter, or 3, not guilty. Voluntary manslaughter is the unlawful killing of a human being by an intentional act. Now, I charge that for you to find the defendant guilty of voluntary manslaughter, the state must prove these things beyond a reasonable doubt. First, that the defendant killed the victim by an intentional and unlawful act which was an assault that was likely to cause death or serious bodily injury. Second, that the defendant's act was a proximate cause of the victim's death. A proximate cause is a real cause, a cause without which the victim's death would not have occurred. If you do not so find, or if you have a reasonable doubt as to one or more of these things, you will not return a verdict of guilty of voluntary manslaughter. You must then determine whether the defendant is guilty of involuntary manslaughter. If you do not find the defendant guilty of voluntary manslaughter, you must consider whether the defendant is guilty of involuntary manslaughter. Involuntary manslaughter is the unintentional killing of a human being by an unlawful act not amounting to a felony, or by an act done in a criminally negligent way. For you to find the defendant guilty of involuntary manslaughter, the state must prove two things beyond a reasonable doubt. First, that the defendant acted unlawfully or in a criminally negligent way. The defendant's act was unlawful if the defendant committed a simple assault on the victim. Criminal negligence is more than mere carelessness. The defendant's act was criminally negligent if, judging by reasonable foresight, it was done with such gross recklessness or carelessness as to amount to a heedless indifference to the safety and rights of others. And second, that the state must prove that this unlawful or criminally negligent act proximately caused the victim's death. A proximate cause is a real cause, a cause without which the victim's death would not have occurred. If the victim died by accident or misadventure, that is, without wrongful purpose or criminal negligence on the part of the defendant would be not guilty. The burden of proving accident is not on the defendant. The defendant's assertion of accident is merely a denial that the defendant has committed any crime. The burden remains on the state to prove the defendant's guilt beyond a reasonable doubt. If you find from the evidence beyond a reasonable doubt that on or about the alleged date the defendant, by his intentional and unlawful act which was likely to cause death or serious bodily injury, proximately caused the victim's death, it would be your duty to return a verdict of guilty of voluntary manslaughter. If you do not so find, or if you have a reasonable doubt as to one or more of these things, you will not return a verdict of guilty of voluntary manslaughter. You must then determine whether the defendant is guilty of involuntary manslaughter. So if you find from the evidence beyond a reasonable doubt that on or about the alleged date, the defendant committed a simple assault on the victim or acted in a criminally negligent way, thereby proximately causing the victim's death, it would be your duty to return a verdict of guilty of involuntary manslaughter. However, if you do not so find, or if you have a reasonable doubt as to one or more of these things, it would be your duty to return a verdict of not guilty. Now, members of the jury, you have heard the evidence and the arguments of counsel. If your recollection of the evidence differs from that of the attorneys, you are to rely solely upon your recollection. Your duty is to remember the evidence whether it was called to your attention or not. You should consider all of the evidence, the arguments, the contentions, and the positions urged by the attorneys, and any other contention that arises from the evidence. The law requires the presiding judge to be impartial. You should not infer from anything that I've done or said that the evidence is to be believed or disbelieved, that a fact has been proved, or what your findings ought to be. It is your duty to find the facts and to render a verdict reflecting the truth. All 12 of you must agree to your verdict. You cannot reach a verdict by majority vote. When you have agreed upon your unanimous verdict, your foreperson should so indicate on the verdict form that will be in the envelope. Now, Ms. Barrett, we have gotten to the fork in the road where we have the original 12 are in a position to begin deliberations. So in a moment, I'm going to excuse them to the jury room, and I'm going to ask you to stay here with us, and I'll give you further instructions in a few minutes. Members of the jury, after you reach the jury room, your first order of business is to select a foreperson. You may begin your deliberations when the bailiff delivers the verdict form to you. Your foreperson should lead you in your deliberations. When you have unanimously agreed upon a verdict and you're ready to announce it, your foreperson should record your verdict, sign and date the verdict form, and notify the bailiff by knocking on the jury room door. You will be returned to the courtroom and your verdict will be announced. A couple of housekeeping things before I release you. Remember, your phones must be turned off when you're in the jury room. You cannot have them on and you cannot use them. I'm going to let you tell me when you want to take a break and how long you want to take a break. Just knock on the door and let the bailiff know, pass them a note saying we want to take a break for 15 minutes or whatever the case may be, and we'll deal with it. You do not need to notify me that you have successfully selected a foreperson. I'm going to take care, and I'll address that with you later on. The only time that you can deliberate is when all 12 of you are in the jury room. So if somebody needs to be excused, just wait until that all 12 of you are back present in the room and you're ready to deliberate. But you cannot deliberate by committee or anything of that nature. All 12 of you have to participate at all times during deliberations. At this time, I'm going to ask you to go with the sheriff to the jury room. And remember, you're only going to pick a foreperson. Don't begin to deliberate until we hand you this envelope. We'll knock on the door and hand you the envelope, and that's your signal that you may begin your deliberations. I'm going to ask everyone else to please remain seated while the 12 jurors are excused. Ms. Barrett, do you have any personal items in the jury room? Okay, can you, if you don't mind, if you would go with the sheriff now and get those and then come back to join us. Are there any additions or deletions, corrections to the jury charge from the state?
Yes, sir.
Or the defense?
No, Your Honor.
Do either of you have any objection to the verdict sheet being sent back to the jury at this